Oh yeah, this was really clever. This was involuntary alienation, which I had never heard before. So that when you sell a piece of property, apparently that's voluntary alienation. I voluntarily alienated my piece of property to you. Okay, here is where I involuntarily alienated my property, which means I sold my property but I didn't really want to. Three concepts that have nothing whatsoever to do with each other, but they all relate to I'm selling my property against my will. The cleverest of all of them is I died. So at the end we're going to talk about I died, therefore my property got transferred. That was an involuntary transfer of my property. But before that we're going to talk about two unrelated concepts. And the first is adverse possession, which we talked about a minute ago about fences and stuff. And that is defined as the acquisition of title to real property by means of wrongful occupancy for a period of time established by law. Okay. Most simply put, we're talking about squatters, but it's a lot more complicated than that. But that was the old story of squatters' rights. You sit on a piece of property long enough, it's yours. The elements of adverse possession are, first, it must be open, hostile, continuous, notorious, exclusive, all these bad things that you had to be doing it in the face of the real owner, obviously, openly, and exclusively. In other words, to the exclusion of the actual owner. You can't be living there with the actual owner and say, okay, I adversely possessed it. You, not the owner, open, hostile, continuous, da-da-da-da. We're going to talk about the statutes in a minute, but I want to go through the concept first for a second. To understand the concept, you got to realize that we got to understand the concept of statute of limitations. And whether you know it or not, you know what this is, because you see it on TV all the time. There's no statute of limitations on murder, or the statute of limitations on burglary is 6 years, or the statute of limitations on arson is 12 years. Statute of limitations are a period of time that the law sets in which you got to bring a cause of action or you lose it. Criminally, that applies to the prosecutor. Bring your cause of action within 10 years for burglary or you lose it. In law, all types of lawsuits have statutes of limitations. We're not going there except to understand there is such a thing. We have statutes that say that, hell, I'll give you an example. We talked through that thing on landlord-tenant. That a landlord has 15 days to tell a tenant whether he's going to impose a claim upon his security deposit. That's a statute of limitations. If he waits too long, he loses it. A statute of limitations is a legal period after which somebody's rights go away. The concept of a statute of limitations is what creates this adverse possession thing. It says to the owner, if you see somebody adversely, openly, hostilely, continuously possessing your piece of property, you got 7 years to do something about it. in Florida. If you don't do anything about it in 7 years, the law assumes you don't care about it, and therefore he gets your piece of property. Now, it's far from that simple, but that's the concept. And the materials talked about 10, 12, 20 years. Well, in Florida it's 7, but with lots of strings attached, and we'll talk about them in a minute, but I wanted to do the concept first. And realize that it can be partial. In other words, the guy didn't have to adversely possess my whole lot 1 here. He maybe only adverse possessed the east 2 feet of it because his fence was here. But if it meets the test of 7 years and taxes and all the crap we're going to talk about, it can be partial. It doesn't mean somebody took your whole piece of property. They can take a piece. This guy can take a piece. You can take a piece of his by a fence line. That's adverse possession. Can be all or part of somebody's piece of property. Realize two things. One that we've already talked about. It doesn't count if you have the owner's permission. Nicole brought that up earlier. You got to be aware of it, and you got to have not consented to it. If you have consented to it, if you said to the guy, you may place your fence on my piece of property, but that doesn't mean it's your piece of property, it's still mine, but I'm giving you permission to put your fence on my piece of property, it's not adverse anymore. It's not hostile, it's not notorious. It's just buddies agreed on something. But you did it against my will, and I did nothing about it for 7 years. That can ripen into ownership. Realize one more thing. Even once we meet all of these tests that we're going to go through in a moment, still doesn't really mean that you're the record owner. So this guy had his fence on my piece of property for 20 years. Well, maybe he owns it, maybe he doesn't. I'm still a record owner. I got the deed. I'm in the tax rolls. People are going to deal with me. If he wants to do something about it and perfect his title, he's got to bring a quiet title suit against me to have a judge decree, yep, you got my 10 feet. So to become the record title holder and to perfect your ownership might require a quiet title suit. But if you meet all the tests under adverse possession, you probably win. If you don't, you don't. But it doesn't automatically give him a deed. He doesn't automatically have a deed of 10 feet. He's still got his deed, I got my deed, but he maybe owns 10 feet of mine if he can prove it in court. Okay, now, one other concept. This is why you've been seeing on TV, one of many reasons that lenders get all bent out of shape when squatters move into the houses that they're foreclosing on. Because they start creating adverse possession timetables. They're starting to run a period of time. There's a dozen other reasons too. What if somebody gets hurt? What if they burn down the house? You know, there are great reasons not to let squatters in your house. But it's one of the issues that a lender's concerned about, is because in Florida, everywhere, if you let somebody adversely possess your property and you know about it, and they're doing it in your face, and you do nothing, that can ripen into ownership. Okay, now let's talk about what that means in Florida. Florida has in its statute of limitations, which is where you go and see that you have to sue in a contract in 4 years, you have to sue for an injury in 3 years, all these statutes of limitations we talk about. They have one called adverse possession under color of title. And the materials talked about this a little bit. That some states differentiate, Florida does. We have two statutes. We have one called under color of title, and we have one called without color of title. And what that means is simply, under the first one, under color of title, you've got some kind of written document, something in writing to establish your claim. Might be a deed, might be a forged deed, but you've got a written document or a court order or a judgment or something in writing that gave you the right to claim that this is your property. Okay, you start with that. But of course, we're already assuming your title ain't great. If your title was good, we're not even talking about adverse possession anymore. So you've got some sort of a piece of paper, but it ain't good, not enough. And you continuously possess that piece of property for 7 years. Continuously. Openly, notoriously, adversely, you did all that stuff in the owner's face. And you never left, but for vacations. And you excluded the owner for 7 years. That can ripen into ownership. The two tests for possession, two things that count for possession are you cultivated it. This happens in farmlands all the time. You cultivated it for 7 years. You farmed it for 7 years. Or you spent money improving the property. If you did either of those two things, or if you didn't do either one of those two things, or you fenced it off. Fenced it off to exclude the owner. Fence it off as if it were your property. You can obtain ownership. So, with color of title, with a written document as a claim, and be in there 7 years,
Cultivated, fenced.
you've got to either cultivate it or improve it, or fence it. Then you maybe will win a quiet title suit to go into court to prove it's yours. That's adverse possession. And of course, it's that section, or protected by a substantial enclosure. This is what scares the hell out of all of us when we do these boundary line things. The neighbor fenced off 5 feet of my property for 7 years. I did nothing about it. Maybe he owns it. Kept me out. Fence kept me out. So it works. But then he'd have to go into court and prove it up. Now, the courts look somewhat favorably upon the guy with color of title because at least you had some business being there. You had some sort of a written document, some sort of a claim that gave you some theoretical right to be there. Without color of title means nothing. Means you're a squatter. You've got no paper. You just moved in. You just plain old moved in. Or moved onto the land. Or moved into the house. Or whatever it was. Or just fenced it in. You did that. Now, if you're going that route, within 1 year after you move in, you got to pay all the back taxes on the property. No matter how far back they may go. You got to go pay all the taxes that are outstanding. And then, within 30 days after you do that, you got to file a form with a property appraiser that says, I'm a squatter. I'm on this guy's piece of property. I paid his back taxes. I've been here for a year. I'm filing a written notice of my claim to try to establish adverse possession. And for the next 6 years, I paid the taxes. Now remember, whoever the owner was, what the hell was he doing not paying his taxes all those years? You know, how was he asleep at the wheel thinking, why didn't I get a tax bill for the last 4 years, you know? But it goes a lot further than that.
You said for the next 6 years, right?
I said within a year, you pay all the back taxes.
Have that.
And you pay the next 6 years' taxes so that you've been there a total of 7 years. The statutory test is you've been there 7 years, and within the first year, you paid all the back taxes. And then you filed all these forms, and then you pay taxes for the next 6 years, and you stay there, of course, for the next 6 years too. Yes, sir?
At this point, do they try to notify the real owner?
That's coming.
Oh.
The tests again are, did you fence it in? Or did you farm it or improve it? Those can count without actually squatting on it. The reason they say those is, you can't sit on every inch of the piece of property. But if you fenced it in, you closed it in for yourself. You're in possession of it now. What we're talking about here is what you need to understand. It doesn't have to be your home. You don't have to live there. In any of these cases. I went and fenced in another guy's piece of property. And I cultivated or improved it, but I had a claim, or I paid his taxes for 7 years. Either way, can create adverse possession. Now, under this second way, though, I'm sorry, did you have a question, Mark? No, okay. Under the second way, boy, the procedures bend over backwards to tell the real owner, look what this SOB is doing on your piece of property. Pay attention here. The property appraiser records in the public records this notice of adverse possession. Mails certified copies of it to the owner. Posts it all over the property appraiser's website. By the way, this property is being adversely possessed by Joe Blow, who's paid 4 years' taxes now. At the end of the time, has to serve personal notice on the owner. Wake up! This guy's about to get year 7 here, you know? I mean, they just bend over so backwards that if you let this happen to you, you deserve it. There's 3 pages here in the statutes of all the things that the property appraiser does, all the hurdle jumping obligations the property appraiser makes the adverse possessor go through. All the forms he has to file year after year after year, and they open separate tax folio numbers. Here's the folio number for the real owner, and here's the folio number for you, the adverse bad guy. And I mean, and then at the end, at the very end of all this, you don't get a deed or anything still. But okay, my 7 years are up. Now, maybe I can bring a quiet title lawsuit against the owner. But that was without any deed or anything. Yes, ma'am.
So you do all of this just kind of hoping the owner's actually dead, right? Because there's no point to the whole thing if at year 7 he decides, oh no, sorry, I was out of the country, now I'm back, get
Yeah,
off.
taking a chance, yeah. But you got to be there for 7 years. Pretty cheap rent. Paying the taxes, ain't bad. Put in a fence, paid some taxes.
True.
Cheap way to have farmland, particularly since farmland is assessed for 0 and there aren't any taxes, you know.
Okay.
Oh, wow, that's true.
Okay, now,
Here comes Frederick.
they've tacked on to the end of this chapter.
That's a strategy.
They've tacked on to the end of this chapter 2 interesting little penalties that are kind of cool. A person who occupies a residential structure solely by claim of adverse possession under this section without filing all these forms the clerk requires, the property appraiser requires, commits a criminal trespass. So this way, if you're there and you don't do all the stuff that's required, you're trespassing and you could be prosecuted criminally. They went one step further, and these they added one in 2011 and another one in 2013, and these are the result of all of these squatters and foreclosed homes things that we're talking about.
This is Florida law we're talking about now.
I'm sorry?
This is Florida law?
Florida law, still Florida law. Yeah, the last one is, any person who occupies or attempts to occupy a residential structure solely by reason of claim of adverse possession under this section, without color or title, and offers the property for lease commits theft under section so-and-so. That makes it a felony. You may recall what's happening. People move into these houses, and then they lease them to some poor bastard who pays them rent. The guy didn't even own it, you know? They created a statute for that.
Makes sense.
Interesting only in the sense of they're doing everything they can to tighten the screws down on people who are gaining title to property this way. Now, interestingly, the chapter talks about all the reasons for adverse possession. I read it and went, what? I can't think of a good reason for any of this stuff. But it is what it is. This is what the law is. The law has adverse possession in it. We care because it can hurt you. And as a property owner, you need to be aware of it. Okay, now, that was involuntary alienation number 1. That was how you can lose your land without really trying. Involuntarily. Involuntary number 2 is eminent domain. Eminent domain is simply the power of the government to take private property for public use with just compensation paid to the property owner. Now, think about it. This can be the federal government, state government, county, city, school boards, and even utility companies. It's not the government, it's a private company, it's a utility company, but the government contracts with the utility companies to say, we gotta have electricity here. And the electric company says, and I gotta have a place to put my power poles, I gotta have easements. So it can even be land taken under eminent domain by private corporations, utility companies. Now, the test of all of this, and where it all gets litigated, but where the doors have been blown wide open, is it has to be a use that benefits the community. Now, that concept of what benefits the community has been opened up so broadly by the case that's in the materials, the Hawaii Housing Authority case, that there's virtually nothing anymore that cannot be construed as it benefits the community. Basically, what this means is the government can do any damn thing it wants to. And take your property and declare, I say it's for a public use. And if the government says it's for a public use, then by God it is. Because the courts have expanded that concept so broadly. In this Hawaii Housing Authority case, I've forgotten the details, but basically a couple of families own all the land in Hawaii. All the land. Nobody owned any land except these couple of families. The government decided that's a bad idea. Let's take some away from them and sell it to other people, just kind of to spread the wealth around. And of course, these families didn't want their property taken away, even though they were paid for it. And it went to the U.S. Supreme Court. Supreme Court said, yeah, that's okay. This is for the good of the community. So, with that case, basically now, the concept is always there. It has to be for a public use that benefits the community, but by God, there is nothing that isn't. And it's the extension of that that has resulted in all the stuff you see today of urban blight being taken by government, knocking down old buildings, and selling the property to private developers. And that's done by the government under the concept of eminent domain for the benefit of the community. Let's take this land and pay somebody for it, even though they don't want to sell it, and let's clean it up. And then, of course, it ends up being for the benefit of private individuals because the government turns around and sells it to developers.
Hasn't that recently changed?
I'm sorry?
Hasn't there been some legislative changes recently concerning that?
Not that I'm aware of, but I don't keep up with this area of the law. They say that certain, as I understand it, there are certain attempts to restrict the ability to do that. But you see community redevelopment agencies all over the country. Broward County has one, City of Coral Springs has one, and they take land and resell it to developers to be redeveloped. Not just to take it for the fun of let's take it, but to improve it.
I think in the land use class, we sort of stumbled over that there seems to be some new.
To tighten it up, to restrict.
Right, to restrict
that
them
land use.
selling back to developers.
I believe you. Thank you for bringing it up, Mark, and I'm just not aware of it. It's just not an area that I keep up with. Now,
The one thing I do remember her saying was that they do pay not just cost, but exact value. What she
condemnation. I want to talk about condemnation.
was it market value
Mhm.
or over it?
It has to be valued.
The constitutional concept is the right of eminent domain. The proceeding is called condemnation. The terms are used interchangeably, but that's the difference between the two. Eminent domain is a constitutional right of government to take property for public use. The procedure by which they do it is called condemnation. Government is required to pay just compensation to the owner. That's market value. In Florida, that's decided by a jury. Know, if you would, that governments always try to do this voluntarily first. They always come to the owner and say, let's make a deal. There are special tax benefits to the owner of selling a property under threat of condemnation. And if you think you're going to hold on to your property and develop it, remember who you just butted heads with. When you said no to them, I'm going to keep it and develop it, but I'll be back next year and ask for your approval to rezone it. You might as well sell it to them, because you're not going anywhere with this property. It's not always taking all of your property. They may take an easement. They may take a little corner off. They may just widen the street and take 10 feet. They may take your whole piece of property and make a park out of it. Partial, total, easements, whatever that is though, they got to pay you fair market value. Fair market value is decided in Florida by a jury. And if you didn't settle with the government, they publish a notice that they're going to condemn your property, and they file a lawsuit and they sue you and their property, and it all gets published. But here's the point. It gets published in the newspaper. And you will find that if your property is being condemned, the first day it hits the Broward Review, you'll have 20 lawyers on the phone asking if they can represent you. And here's why. It's free attorney's fees for the owner. The owner's attorney's fees get paid by the government condemning authority. So the lawyers would love to represent you. And just like the signs of, no recovery, no fee, well, no fee, period. No fee no matter what. So, that's the proceeding of condemnation pursuant to the right of eminent domain. Now, number 3 type of involuntary transfer is death. You died, your property is going to be transferred. Now, you need to know the difference between intestate and testate, and I'm going to try to help you with that. You hear people's will called a last will and testament. Testament is the word. If you die with a will, you die testate. You had a last will and testament. The guy who signs a will is a testator. All right, that's all testing. That's with a will. We're going to go there in a minute. But to follow the book, The first way to go is intestate succession. So, testate with a will, intestate, no will, or your will was invalid for some reason. And what that means is, your property is going to pass pursuant to law. You didn't write a will and decide where you want your property to go, so the legislature has decided for you. Those are called statutes of descent and distribution. Florida has them. Now, we're going to go through the Florida statute in just a minute. But I want to show you a concept that you need to know, to understand intestate succession, or, even though the book doesn't think so, testate succession too. And it's simply this. The decedent dies. For whatever reason, by his will, by statute, he leaves his property to his 3 children. Okay? Maybe he had a will, said, I'll leave all my property to my 3 kids equally. Unfortunately, this son died first. He's gone. He died before Dad. But Dad said, leave my property to my 3 kids. But he's gone. What are we going to do with his share? Well, before he died, he had 3 kids. Now, concept called per-stirpes. P-E-R, one word, stirpes, S-T-I-R-P-E-S. The concept of per-stirpes means that the descendants of a deceased person step up and take his share. Okay? Our intestate statutes operate per stirpes, and they say per stirpes. And wills, everybody says in their will, per stirpes. So simply, here's what happens. This guy gets a third. This guy gets a third. This third would have passed here. So this person gets a 9th. And this son gets a 9th. And this daughter gets a 9th. These 3 people stepped up into the shoes of their deceased ancestor, who predeceased the testator. And this stepping up to share the share is called per stirpes. Yes, ma'am.
And that's included in all wills generally, correct?
I'm sorry?
That's included in all wills generally?
Not included, normally it's put in wills. In a will, you say whether you want per stirpes or per capita. Now, if in a will, okay, first, and we're still on this concept of the statute. In the statute, if property was to pass, let's say there was no spouse and property was to pass to the 3 children, the statute says in all events, inheritance shall be per stirpes. So in all events under the statutes of descent and distribution, this is going to happen. Now I want to tell you what the opposite is, though. The opposite is per capita. And per capita means, we create a class of all of the living children and children of the deceased child, and we put all of these people in a class together. And then what happens?
Split it all.
20% each. Okay? These guys aren't happy. These guys are real happy. That's per capita. Okay? So we have per stirpes was the first way, and we have per capita. You know, you've heard per capita before. Per capita income per person. That's it. Per person. Pretty simple.
That's why you start knocking off family members.
I'm sorry?
That's why you start knocking off family members.
That's actually
There
a
you
bad
go.
idea to
Yep.
start knocking them off. Because look at how the split
Knock off the
goes.
kids.
You need to understand these concepts to understand the statute.
Going to hell.
So now we're going to go through the statute. Here's Florida statute. This first part is really weird. It's about the spouse. Part of it's easy and part of it's complicated. And I'm going to give you the easy part and then just throw the rest at you. They'll let you sort through if you care. If there are no children, this guy died, had no children, but had a spouse. Pretty easy. Spouse gets it all. No brainer. Okay? This one's a little surprising. If the spouse has one or more children, I'm sorry, if the deceased has one or more children, and these children are also the children of the spouse, believe it or not, the spouse gets it all. That's pretty weird. Here's the theory. They're her kids too, she'll probably leave it to them.
Should probably protect them.
And since it's their mother, they probably want her to have it. That's how the legislators came up with this idea. So if the deceased has only a spouse and no kids, that's pretty easy. The spouse gets it all. Or if he has kids, but they're also the kids of the spouse gets it all. In a bunch of other weirdo situations, the spouse gets half. And this is all about, well, did she have children of her own, and she has some children with him and some children with somebody else? She gets half. So the first two situations, she can get it all. There's only a spouse, that's easy. Or if there are children that belong to only that couple, she gets it all. In all other situations, spouse gets half.
That's
Okay.
specific to Florida?
I'm sorry?
Specific to Florida?
Yeah, that's Florida law. Every state has a different law. I'm reading you from Florida statute. So it goes on to 3 or 4 more of these things about, this kid is not the child of her, or her child is not the child of him, and all those cases. You read through all that crap, spouse gets half. All right, now, from there forward, there is no spouse. What happens?
Goes to the family.
Or there was a spouse who took half. What happens to the rest?
No kids.
That's when we
too.
start going through the pecking order. But realize, it's not just when there's no spouse. It's after the spouse got her half, then what happens? And remember, in all these cases, they didn't have a will. Guy died without a will, what are we going to do with his property? Okay, here we go. First, children. The children of this guy. If there was no spouse, everything goes to his children. Okay? Now, the statute doesn't care if it was with 4 different wives. Because we're not going to get there. We don't care about that anymore. They are his children, and they each take differently. They each take equally. Okay. And The statute says at the end, all descent under this statute shall be per stirpes, which is what we talked about earlier. So it will be this factual situation. The statute would have said, give it to his 3 kids, but one had already died, so the 3 grandchildren step in. Per stirpes, which is the 3rd, 3rd, 9th, 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 not the 20, 20, 20. That's per stirpes. That's what's going to happen. Now we just start going down the pecking order. Okay, if there are no kids, father and mother, or the survivor of them. No father and mother, brothers and sisters. And the descendants of deceased brothers and sisters, which means per stirpes. It means your nieces and nephews and stuff if your child has died, or your sibling has died. And we go on after that. Then we go grandmother and grandfather, and uncles and aunts, and deceased uncles and aunts, and children of deceased uncles and aunts. And then half to the paternal side, half to the maternal side. We get down through all this stuff. All right. If we get down to the bottom of the barrel here, and we've been through every one of these things, we can't find anybody. It goes to the state. State of Florida. That's escheat, E-S-C-H-E-A-T. Property will escheat to the state if there's nobody to take it. Now, what I want to say to you is that all of these concepts we just talked about, per stirpe, per capita, and escheat, the materials discuss them as if they only apply to an intestate estate, meaning no will. They apply equally to a testate estate. And interestingly, in a testate estate, let's say I left all my property to A, B, and C, and I just quit right there. And A, B, and C predeceased me. Well, then what are we going to do? Well, then we'll come back to the statute. And we'll go through the statute, and we can't find it by there either, then we get to escheat. But the point is, you can have a testate estate, but nobody to take it. Or you can have an intestate estate, or an estate that switched over to intestate because there was nobody there. In any event, you get down all the way down the street to the state. Yes, ma'am.
Who ensures that all the proper channels are followed for an escheat?
Who does the what?
Who ensures that all the proper channels are followed before it becomes an escheat?
We're going to talk about that in a minute.
Okay.
That's the estate proceeding. That's how we go through an estate administration, figure out who are the heirs and distribute the property to them. We'll do that in a moment. Yes, sir.
Where are you supposed to keep your well?
Where what?
Where do you keep your well?
In a fireproof box.
Safe deposit box is the best place, but you got to be sure
Are
that
you just making a bunch of copies and
you got to be sure that somebody can get access to your safe deposit box. Because they need your will to be appointed to open an estate and to create an administration to be appointed as personal representative. And until they're appointed as personal representative, they can't get in your safe deposit box. So what you do is you make sure that at a minimum, somebody has copies. That's enough to get an estate proceeding started with a copy. But then ultimately they have to produce the original, but once the court appoints a PR, that gives the PR the right to go into the safe deposit box and get out the original. But I strongly suggest to you, if you do keep it in a safe deposit box, lawyers used to keep them in will safes, and the reason they did, because they wanted to handle the administration of the estate for 3% whenever you died. So let's have the family have to come in here and get the will from me, and oh, by the way, wouldn't you like me to handle your probate for you for 3%? But that became a burden. If you lose one, you're in big trouble. So now everybody gives them back to the client and tells them to put it in a safe deposit box, but tells them to make sure somebody else has the right of access to that safe deposit box. Have the box jointly with somebody if you can, because then they can get in there if you're dead. However, if you appoint somebody as your agent to get in there, and the bank knows you're dead, they ain't letting them in. The minute the bank finds out you're dead, they're locking up the box.
Why?
Unless it's a joint box, and it belongs to the survivor. But if you just gave somebody a power of attorney to get in your box, your power of attorney is void on your death and nobody can exit. The moment we talked about that with powers of attorney before. That's the risk with powers of attorney. The moment you die, you revoke it. They may not know it's been revoked, and they might let you in once or twice, but as soon as the bank finds out you're dead, they're locking up the box. Unless it's a joint box, in which case it belongs to the, remember, joint tenants to right of survivorship, belongs to the survivor. And they can get it out. So it's good, but you still want to have it there because it's safe there, because it's not going to get lost, because in order to do a probate, which we're going to talk about next, you're required to furnish the original to the court, the original. And there are ways around that, but it's expensive. We can bring a lawsuit to establish a lost will. Let's give me some more money. But it can be done. But it's not smart. But you want it somewhere where somebody can get access to it quickly when you die. So they can go into court and say, Your Honor, I'm the PR nominated in the will, please appoint me. Let's open an estate. And we'll talk about that in just a second. Okay. But that is it, basically, for intestacy. No will. Now, testate succession means you had a will. We're going to talk a little bit about a will, but this is not a course on wills. But I want you to just understand the basics of what a will is. A will is a written instrument. The material says that permits the distribution of an owner's property after death. It directs the distribution. It doesn't permit. It says what's going to happen to it. It directs. I want my property given to A, B, or C. Okay. It's got to have certain elements to be enforceable. There are 5 of them. You don't have to learn them. This is not a course on wills. But, just to get the drift of what we're talking about here, it's got to be in writing. That should be obvious. But every now and then you see there are exceptions for, soldiers and sailors on their deathbed and stuff like that. But your will's got to be in writing. It's got to be signed. Pretty obvious. It's got to be witnessed. Pretty obvious. No, not so obvious. Got to be written, got to be signed. Everybody knows that. All right. It's got to be witnessed in Florida. A will requires 2 witnesses. A will does not have to be notarized, but we do it. And here's why. After somebody dies, in order to prove a will is valid, somebody has to go into court and swear that I was a witness and he signed it, and therefore it's valid. If it's notarized, you don't have to do that. You don't have to go find the witnesses, and you don't have to get the witnesses to go down to court. The concept in Florida is called self-proved. The word probate, we're going to talk about probate in a minute, but probate means proof. Means proving a will is valid, and the way you prove a will is valid is by having witnesses testify that it's valid. But in Florida we say, but if it's notarized, you get to skip that step. So automatically you eliminate the step of having witnesses go down to the judge and say, Your Honor, I saw him sign it. So in Florida, written, signed, witnessed, and notarized is a real good idea, but not required. Okay, now, it's pretty obvious that a will says in it, here's what I want you to do with my property. We could talk through the 100 things that the will says, but that's not what we're here to talk about. We're here to talk about real estate. But there's one concept I want you to realize, because the materials talk about them, and you ought to be aware of this. It's called elective share. It's the spouse's elective share. And what this simply means is, if a spouse doesn't like the way the way he or she was treated in the will, you can elect, simply put, to take 30%. So what that means is, in Florida, you cannot disinherit your spouse, period.
I'm never moving.
If you write a will, give all the property to your girlfriend, your wife gets 30%. Now, the statute is hugely complicated in terms of coming up with that, what they call the elective estate. They try to bring in all kinds of things. You know, people have property titled all different ways, and trusts and this and jointly and stuff like that and all. So they try to come up with a way to create whatever that elective estate was, to see what is the value of that estate. And then the spouse gets 30%. Now, if the spouse got everything under the will, she wouldn't take it. Spouse may only get 10% under the will, so they'd like to have the elective share. That's the deal. Legislature. Now, interestingly, there is no such protection for your children, period. Children don't get an elective share. Children don't get anything unless in the will you give it to them. And if in your will you give everything to the Humane Society, the spouse may get 30%, but your kids aren't getting any. Okay, yes ma'am.
What about homestead?
What
Does
about-
that have to be pooled, and does she get 30%, or because she lives there, does she get the actual home?
Well, that depends on how the home was titled, right? Was it titled by the deceased owner? If it was titled as tenants by the entirety, she owns it outside the will, by right of survivorship. We're gonna talk about
Yeah,
that
but
in
if
a
it was
minute.
just in his name, it becomes a part of the estate, and she only gets 30%, even if she lives there?
No. The homestead statute says, the homestead shall descend with a life estate to the spouse and remainder to the children.
Gotcha.
So, as to the homestead, it wouldn't matter what you said in your will. You have a separate rule by law that says what's gonna happen to the homestead.
Always protect.
If it's in only the deceased name, okay? If it's in joint name, well, hell, she owned it all anyway, right of survivorship. Okay? All righty. Now, I want to talk about administration of estates. And I want to talk about this simply with a focus on what I think might affect you in the property business, to give you a limited familiarity with what's going on in an estate, not how to handle estates, not how to handle your estate, but I want you to know the concept of administration of the estate is what we used to call probate. And what it is, it's the management and settlement of the estate of a deceased person by the court. And the reason we call it probate is the first thing that the court does is try to determine whether the will is valid or not. Number one, is the will valid? And number two, was it your last will? Some people have 10 wills. We've got to get to the last one. The first word in every will is, first paragraph, I hereby revoke all my prior wills. But what if the one somebody finds when you're dead is 3 drafts back, you know? I mean, it looks valid as hell. Original, safe deposit. What if there are 8 of them in a safe deposit box? And what if the last 2 that you didn't put in the safe deposit box? But we got to figure out, is it a valid will? And is it your last will and testament? That concept is called probate, and that's proving up the will. Now, you remember from our chart of courts, the circuit court in Florida handles probate matters. There's a division of the circuit court called the probate division. And that's where these matters are handled. Now, even though it's the probate division, we no longer call it probate. In Florida, the word is administration. With or without a will, testate or intestate, when you're dead, you're going to have an administration. Yes, ma'am. Was that a question? Okay. You're going to have an administration. 3 things are really going on there that are irrelevant to you. The court is going to appoint a person named the personal representative. The PR. You're going to hear about the PR. Used to call them all kinds of names, administrator. The book goes back and forth between personal representative and executor and administrator and all those things in Florida. It's the PR, the personal representative, whether your estate had a will or didn't have a will. Okay. Secondly, the duties of the PR, the materials talk about 4. I think of it as 3. And they're real simple, but you need to understand what the PR's job is. Number 1 is to assemble all of the assets of the deceased. That can be a treasure hunt. I have served as PR of about a dozen estates. Friends, parents of friends. It can be a treasure hunt. People that keep lousy records. God, the stuff that you find stashed places, sometimes they don't have an accountant. Nobody knows anything about what their assets are. You got to find and preserve all the assets. That's the first job of the PR. Second job of the PR is to settle and pay claims. Stated simply, you don't need to know this, but I just want to tell you how this happens. When somebody dies, they publish a notice of administration in the newspaper, and that says, if the decedent owed you any money, you got 90 days to file a claim in the estate. If you don't file a claim in the estate, your claim is barred. Period. That's what brings the creditors out of the woodwork. And it should. Because the idea is, let's get all the creditors paid. So the second job of the PR is to receive all those claims and settle them, and maybe pay them, maybe dispute them, maybe litigate them. Maybe say you're full of crap, sue me. I don't believe you. I don't think the deceased owed you $20,000. Prove it, sue me. But if the claimant waited 6 months to do that, it's a laydown. So 90 days to file a claim, and then the PR may compromise it, may offer to settle it, may pay it, may offer to settle it, may dispute it, may litigate it. But that's the second job, is pay off all the claims. And you know, funeral bill, last illness, doctors, nurses, hospitals, all that stuff. Okay. The third job is to distribute the assets, either in accordance with the statute, as Nicole asked. He's going to figure out who are all the heirs. He's going to report to the court. I have found 2 children and 3 grandchildren. And Your Honor, I think that's who ought to get the estate. Your Honor says, yeah, good idea, do it. He's collected all the assets, maybe sold pieces of property, and that's where we're going to go in a minute. But he's gotten all the assets together, and he's got to distribute them. Those are the 3 basic jobs. Collect the assets, pay the creditors, distribute the assets. Now, yes ma'am.
I just have one quick question as it relates to finding all the heirs.
Yeah?
How do you go about doing that?
Well, usually you're a family member.
You're a family member, but do you have to prove it? Do you have to say this
If
member?
you have to prove you're a family member?
Yes. Do you have to prove it to the
Do
to
you
the
have to
PR?
prove it to the judge who's going to appoint you? Probably not.
No, to the PR who's the PR
Oh, wait a
who's
minute.
searching for heirs. Do you have to prove that you are in fact an heir, and if so, how?
Maybe, if he doesn't know you. If he wants proof.
Isn't there?
If he wants proof, he'll ask you for it.
There's something called a
You know,
genealogist or something like that.
If you're my brother's kid,
Genealogist.
if you're my brother's child, I probably know you pretty well. Okay? No, I'm not going to ask you for proof. If you're my brother's child who disappeared 25 years ago, and decided that here's a good day to show up, prove it. Okay? It's the PR's job to make sure he gets it right. He can ask you for proof if he wants it, or he can not. If he screws up, he's liable to the court. PR posts a bond to the court. If he makes mistakes, there's a bond there. Now, the important document that the court gives to the PR that you're going to care about is called letters of administration. People call them letters. Let me see your letters. That is a court order signed by the judge that says, I, the judge, have appointed Steve Ginestra as personal representative of the estate of Mr. D, and he has all the authority of this court, basically, to do whatever the hell he wants to settle the estate. Now, I skipped about a year of proceedings and accountings and motions and orders and all that stuff and how a whole estate goes through and settlement and 706s and okay? But these are the things that are important to you because the letters of administration are what give the PR the authority to deal with the assets of the estate. And in order to distribute, let's say just in this simple case, this guy had a house. How are we going to give the house to 5 people in a share like this? Or not. PR is going to sell the house. You're going to deal with it. You're going to maybe buy the house from the PR. When you look at record title's still in D. D isn't around, you hunt it out, he's dead, you go find the estate says I'm the PR, I've got letters, you're going to deal with me. How do you know I've got the authority? You're going to want to see a copy of my letters of administration. And you're going to want to know they're still in effect. So you're going to check with the court file when you're dealing with me to make sure I still have letters. The letters may be 3 years old and the estate may have been closed a year ago. The letters aren't any good anymore, but they sure look pretty good. Got the signature of the judge, they got a pretty corporate seal on there, or pretty judge seal. Letters look great forever, but they may no longer be in effect. So you're going to check with the court to make sure the letter's still good. I may have resigned, I may have gotten fired, and they may have appointed a new PR. So you want to check the court file and see if letters are still outstanding in favor of the PR you're dealing with. And be aware. So I'm talking to you as a buyer or as a realtor, you're going to make a deal to buy this piece of property from the PR. When you get to closing, obviously, there are going to be all kinds of title requirements the title company is going to impose. They want to know estate taxes are paid, and they're going to review the whole estate file, and they're going to check to make sure my letters are still good so I can sign the deed. But be aware of this. If there was a will, I can probably sign a deed and sell the property to you. Probably. You got to go look at the will and see, did the will give me the power to sell real estate? If there was not a will, or if there was a will that didn't give me the power to sell real estate, the court has to enter an order approving the sale. And what that means is, in your sale transaction, you may find out at the last minute you're about to close, I don't have the authority to sign a deed. And then the lawyer for the estate, my lawyer, is going to have to go petition the court and have a hearing in 6 weeks and get the sales contract approved and let the court say the PR has the authority to sign a deed to sell this house for $300,000 to Mary and John. And that can really screw up your closing. So you want to find out early on, does your PR have the authority to sign the deed? Because if he doesn't, you're going to need to get a proceeding started.
Can you dictate that the property be sold in your will?
I'm sorry?
Can you dictate that it has to be sold and the proceeds?
Oh, you can dictate that it has to be sold, or you simply, the last section of your will is about 3 pages where you say, here are all the powers of my PR. And the first one is to sell any of my assets. You always give the PR the power to sell your assets, except usually you say, PR, please follow my instructions regarding items of personal property. Please give the bracelet to Mary. Please give the necklace to Mom. Items of personal property. And it may even happen more on piece of real property. You may say, PR, I don't want you to sell this house. I want you to deed it to these people. And let's watch them go at each other and see who's right. You can do that if you want to.
The entertainment.
But usually, in order to make this distribution, the PR would rather have $300,000 and then give it 100, 136, 30, then the PR knows how to divide it. But if that instruction were in there, the PR would then execute a deed to Bill and Bob and Jane and Susie and, you know, 1/3, 1/3, 1/9, 1/9, 1/9. PR is going to do whatever the testator instructs him to in the will. That's why I talked about the will directs what happens to your property. It doesn't permit, like the book says. You say right in there exactly what you want to happen. And if you say, I want a specific piece of property to go to a specific person, it's the job of the PR to deed it to that person. But if you don't say that, and you just say, I want my assets to go 1/3, 1/3, 1/4, 1/4, 1/4, then the PR liquidates most of them, because he can't divide, most of them he can't divide up. He can't divide up the bracelet anyway, or the piece of property. So the PR exercises his discretion and sells the assets. And if you're buying an asset from him, then you want to know that he has letters and he has the authority to sell, because then he can pass good title. And he's going to use a fiduciary deed, like we learned earlier. Where in his fiduciary deed, he's going to say, all I'm telling you is, I have the authority to sell it. Not warranting the title. I'm giving you a fiduciary deed that says that I have the proper power to sell. But that doesn't mean that he does. You're going to check that out anyway. But that's all he's going to say in his deed.
In the will, you can add restrictions and deeds as well, right?
I'm sorry?
You can create deed restrictions in a will as well. Say, oh, I want you to deed this to such and such.
You could tell the PR, I'd like you to sell my piece of property, and I'd like you to put a deed restriction in there that it never be a pig farm. Yeah, you could do that if you want to. Sure. Okay, one more point I want to make. I want you to realize that probate, I want you to realize that administration applies only to assets that are in this guy's name alone, okay? If he owned something as joint tenants with right of survivorship, well, it already passed to that person, right? It's not in his estate, it's not in his administration, it passed by operational law the moment he died. The PR has no authority over it. It's not in the estate, the PR has nothing to say about it. If he had something that buys tenants by the entirety, for the spouse, the moment he died, it passed to the spouse. We're not even talking about any of this stuff. Not in the estate, not in the administration, not within the control of the PR. And it's not even just stuff that's in his name alone. Remember tenancy in common? We have a piece of property owned by A, B, and D as tenants in common, okay? That 1/3 interest is in the estate. It didn't have right of survivorship. It didn't pass by operational law like these other ones did. So the tenants in common property that we said, remember, it's going to pass to his heirs? It is. It's going into the estate. And what's going to happen is A and B are going to have a new partner. Whoever the personal representative sells it to. Hell, maybe they're going to have 5 new partners. But it's only going to be a 1/3 interest anyway. In which case, this is a 9th, and this is a 9th, and this is a 27th, you know. But the point is, realize that the estate has in it only the assets of the deceased, not those that are held jointly with other people, because they don't pass pursuant to the estate. Okay. That's another full year course in law school, how you handle estates, how you probate estates. It's just, it's a shame to try to treat it so abruptly, but I hope that that's the important part of what you need to know, which is you're dealing with the PR, you need to know he's got the authority. And so, we didn't make it to chapter 19, recording process. We didn't make it to chapter 20, which was what do we do at the closing and the closing statement that I sent you last time, so we'll go through that next. So Next class, we've got chapters 19 and 20 and the rest of the book. 19 and 20. 20 is important because we're going to go through a closing statement. 19, the recording process, not so much so. And 21, which is mortgages, that's important. We're going to spend a lot of time on mortgages next time, and we're going to go through a mortgage. And if we don't get any further than that, oh well. Okay.
The final is the next one.
I know the only reason you're still here is to get the midterm.
Final is the next one.
Yeah. We're done good.
Shit. You done, son.
I'm trying to think if I plan something, would you guys like roll out? You're not gonna take it.
So forgive me, I'm going to hand these out because that's going to help me. So that may,
Yeah, man. I mean, that's it on the fifth? Yeah, I know, but I'm saying it's like,
Uh-oh, we get to see damage. Damages.
I need to look, I need to look.
Happy Thanksgiving. We've got 3 weeks till the next class.
Oh, we got some time there.
I gotta read the book. I'm taking a shirt off.
Jesus.
You work so. Oh my God, really?
Yeah, so,
I almost gave her all too.
let's up, I mean,
So you figured out what it was?
Yeah.
Alright, I'm gonna go use the link.
Damages done, so.
I'll take it. I'll take it and read it over.
I'll let you know how I did. Okay. I'll break it to it.
trade grade, I found out. Yes, the project just down. They like just legit just closed on these now.
Just cut to the last page.
So it's like it's a little month out.
Michael?
Thank you.
The page is the grade on. Oh,
That's good. I know you're here. I was tripped over another page. Thank you.
I'm scared of that's it, you know, if you write that. I'm hoping he gives like another for like a head of the class.
Yeah. No,
Who do I have? Dylan?